First of all, I mean, in terms of the milestones of the application of the law has been enacted in July, and the effective date of the law has become effective since around 10 days ago. So we can say that now the law is up and running and effective as provisions. And the law also states that the executive regulations, which is the more important part, will be enacted within 6 months from the date of effective of the law. So we have to we will calculate around 6 months from the 16th of October in order for the Minister of Telecommunication to issue the executive regulations of this law. And finally, the law gives another 1 year for all the concerned parties, I mean, of this law to adapt to the provision of this law from 1 year from the effective date of the issuance, or I'm sorry, from the official issuance date of the executive regulation. So the milestones is now effective 16th October. We'll add another 6 months from that date for the issuance of the executive regulations, which should provide more and more details about the specific issues under the law. And then all the concerned parties of this law will have 1 year from the issuance of the executive regulation to adapt to the provision of this law. So back again to what was the situation before the enactment of this data protection law. Given our experience with most of the clients, they always receive this kind of questions, whether Egypt has adapted a dedicated data privacy law or not. And we also receive a lot of questions related to data privacy and data protection. So the situation before the law was that starting from the upper, which is the Egyptian constitution, with all the previous constitution, for instance, 1971, and ended by the amendment to the constitution in 2014, they always provide this general principle, which we consider a constitutional principle and right, that the private life is protected and privacy is protected, and all the communications, telephones, emails, the security of and secrecy of this kind of communication should be guaranteed by the constitution. So it was always a repetitive of a general principle as constitutional, and based on this principle, the law should be followed. There are different laws where the data protection and data privacy were located in different laws, and we always, I mean, having this thorough research to provide the legal advice for the client of how we can highlight the obligations for the data privacy. So we start, for instance, for the penal code, which has been issued in 1937, which is a very long time. They were tackling some provisions on the disclosure of secrets and the prohibition of recording calls or taking photos without the consent of the injured person. So the law will provide some penalties on the breach of this kind of obligations, aiming at protecting the privacy of the persons. Also, there were another provision which is putting more restrictive obligations on the professionals like doctors, while in due course of their profession, they can get access to very confidential information and secrets to their patients. And of course, also the penal code states in the penalty in case of breach. Moving to in terms of the chronological and recent laws, for instance, I mean the Egyptian telecommunication law, which has been issued in 2003, they provide a general rule for protection and putting standards to protect the secrecy of the people they are using the telecommunication, which is an obligation on the operators, like the mobile operators or internet operators or whoever service provider. But unfortunately, it was provided in a very general term without providing specifics and condition how this is going to be implemented in practice. Moving also for the labor law as well, in certain parts of the law, they provide an obligation, for instance, for the employee to abide by any confidentiality raised and highlighted by the employer in order to abide by this kind of obligation. The banking law, of course, most of us, we know that the banking law is stating on the secrecy of accounts, which is a very important obligation on the banks. This has been repeated in the old law and the old law in 2002. And now there's a new law, banking law, reflecting the same obligation of secrecy and confidentiality of the personal accounts of the people. The antitrust law also is stating in some areas where the antitrust employees, they have to keep in a strict confidence any information, of course, because given their nature of their work, they're getting getting access to very confidential commercial information of the concerned companies. So the law in certain areas will be putting more restrictive obligations on the employee of the antitrust agency to keep this in confidence. As a kind of development of the law as well, there's the Egyptian law, which is issued and enacted in 2018 on the anti-cyber crime law, which is putting some restriction in terms of abusing the data by whoever receiving this information by sending messages for marketing or whatever. So in the absence of any prior consent, an explicit prior consent from the concerned person, this will trigger criminal liability. So to wrap up and recap the situation, we can conclude that there's no dedicated law before this, the issue of the data protection law, and the data privacy and issues were tackled in different areas as general principle and some kind of obligations under different laws in Egypt. So I think it was a good step for Egypt to start to adapt a dedicated data protection law whereby they have a main reference to regulate the rights and obligations of all the concerned parties in this regard. I would like, before moving forward and giving the stage to my colleagues, to continue, I would like to start with a general statement about what we found out so far from the provisions on the law and
في منصة إدارة فؤاد تعقيم. جاي النهارده.
And I think somebody should mute his microphone. Are you following?
Yes, I'm following.
Okay. So before moving forward with the details of the major provisions under the law, I would like to give this general statement and general recommendation about what we should do as a business now, given the enactment of the law at this stage, pending the issuance of the executive regulations, which of course we would expect and assume that it will cover a lot of details of a lot of general and generic provision provided under the law. So our statement that given our review of the law, we see that it's in some areas it has been adapted based on the GDPR or the General Data Protection Regulations in Europe in many areas. Maybe it's not in a complete manner, but maybe the principles are covered in a way or another. More importantly, that I would like, given our initial review of the law and how this will impact the business, given the enforcement of the law at this stage and pending the issuance of the executive regulations, I think this law and the provisions in terms of the rights and obligation of the holder of data, the controller of the data or processor of the data, it is very important now. And of course, I think many of the participants and our audience, either they are in-house counselor or in-house lawyers, and of course, especially who is working with international companies. We need, I think, immediately now to review all our contracts, either externally or internally, because at first glance we see that at this stage, having the explicit consent from all the concerned parties, like from your employees or dealing with customers or whoever that as a service provider or supplier or whoever, I think it's getting imminent that we have to make sure that our contracts and dealings are somehow covering and provide specifically a dedicated clause for the data protection. So I think at this stage, and again, as pending having the full picture on all the details as expected to be covered under the executive regulations of the law, it's important that each of the business internally to have a complete due diligence on all their dealings and contracts to make sure that the contracts, either the existing or the future one, will be tackling this important topic and supporting your business, and by ensuring that you are receiving the explicit approval from the parties that you're dealing with for the purpose of collecting this data, sharing this data, and processing this data, especially as given our humble experience, most of the international clients, they controlling and processing the data with third parties. And it's now we have to link between the international practice, which is coming from the headquarters outside, to adapt and to be adhere to the local requirements as outlined in the new data protection law. So I think this conclusion at this stage is very important, and this recommendation in order to move forward. And of course, this should be revisited once the executive regulation has been issued, in order to ensure full compliance with all the regulatory matters and the statutory issues as contemplated under the law. Before I move to I move the stage to my colleague Habiba. We have this general overview that a lot of issues under the law is still very generic, still very general. The law has not been completely tested, of course. It is the beginning of the enforcement of the law, and of course, the more application would trigger a more clearer vision on how this law will be enacted in practice. So you may expect that we cannot find firm answers for certain questions, but of course, we'll be ready to provide whatever support or answer in the questions based on the current situation of the law and in the absence of the details under the executive regulations. So thanks for participating again to this, and I'm going to move the stage to my colleague Habiba to continue with the presentation, and then my colleague Batool will continue with the rest of the presentation. Thanks again, Habiba.
Hello, everybody. In the beginning of the presentation, I prepared to state for you 6 exceptional cases where the law doesn't apply on the personal data. First, Personal data of third parties when it is processed only for personal use. And the second case, if the personal data is processed for obtaining official statistical data. And the third case is official data processed only for media purposes. And in this regard, we have to put into consideration to not violate, while processing this kind of data, the laws governing the press and media. Regarding the fourth point and the fourth exception, is the personal data related to judicial records, investigations, and judicial proceedings. And for the fifth exception, is the personal data held by national security authorities. And the last exception that we have in the law is for the personal data held by Central Bank of Egypt. And in this regard, there is an exception for the money transfer companies and the currency exchange companies, as both of them fall under the scope of this law. So these are the only exceptional cases for the personal data that doesn't fall under the scope of this law. Now we will move to the skeleton of the Egyptian data protection law. The skeleton of this law includes definitions, rights of the data subject, obligations of the controller and the processor, conditions of collecting and processing the data, data protection officer, procedures of granting access to the personal data, cross-border movement of the personal data, direct electronic marketing, license, permits and certifications, requests and complaints, administrative sanctions, and finally, crimes and sanctions. Starting with the first point, the definitions. The Egyptian data protection law defines the term personal data as any data relating to an identified natural person or one who is identifiable in a direct or indirect manner by linking him to such data and to other data such as name, voice, photograph, and identification number, and so on. And regarding the second definition, the sensitive data, it is the data disclosing psychological, mental, genetic health, biometric, or financial data. And also, it includes the data relating to children by all its sorts or by all its kinds. And regarding the third term is the holder. The holder is any natural or juristic person legally or factually holding and retaining personal data in any manner or by any means of storage, regardless of whether that person had such data initially or it was transferred to him by any means of transfer. When it comes to the holder definition, we have to mention that the law didn't specify any obligation or rights to the holder, which is not the same case by comparing him to the controller under the Egyptian data protection law, as the legislator stated in this law the controller's obligation. And by checking the definition of the controller in this law, we'll find that it's similar to the holder, as both of them is any natural or juristic person who has the right to obtain personal data. So, our interpretation in this regard is that the definition of the controller covers implicitly the holder, as both of them are persons who hold personal data. For now, this is our interpretation for this term. But we will wait until the executive regulation will be published, as it might explain more the role of the holder and includes more clearer image for this term. Now I will move to the second point in the skeleton, which is the rights of the data subject. First, regarding the definition of the data subject, he is any natural person whose personal data is processed electronically. And in this part of the law, the legislator stated the rights of the data subject to protect their personal data as follows. The data subject shall have the right to know, review, and access and appoint personal data belonging to them, which is held by any controller or processor. Also, the data subject shall cancel the prior consent concerning the processing of their personal data. Also, they have the right to rectify, edit, erase, or update their personal data. And they have the right to limit the scope of processing their data. Also, they shall have knowledge to any breach that may occur to their personal data while being processed. And they can object the processing of personal data or its result whenever it's contradicted to their fundamental rights and freedoms. So this is the rights of the data subject stated in the law. And regarding the fees of the processing of this data, the law stated that the data subject shall pay to the controller and the processor the fees of this service, of the processing service offered by them, that shall not exceed 20,000 Egyptian pounds. So this is an overview about the definition and the right of the data subject under this law. And now we'll move to our third point, which is the obligations of the controller and the processor. In the beginning with a joint obligation on both the controller and the processor. The law in this regard stated that both the controller and processor shall, upon their knowledge of the occurrence of any breach to the personal data handled by them, to inform the Personal Data Protection Center. And in case this breach was for a data related to national security protection consideration, the Personal Data Protection Center shall notify the National Security Authority immediately and provide them within 27 hours from the date of the knowledge with the following. First, a description of the nature of the breach, its form, reasons, and determine the effect of the personal data. Second, the information of the competent data protection officer. Third, the potential consequence of this breach. And fourth, a description of the procedures taken or proposed to be taken to limit the breach negative consequence. And fifth, the documenting of any breach of personal data and the rectification procedures undertaken to this breach. And the last one is to provide any other documents or information requested by the Personal Data Protection Center. And we have to mention in the end that the controller and the processor shall notify the data subject in case of the occurrence of any breach for their data within 3 days from the date of their notification. So those are the joint obligations imposed on both the controller and the processor. And now we will start to mention the obligations of each one of them specifically, separately. First, start with the controller. The definition of the controller under the Egyptian Data Protection Law is any natural or juristic person has, by virtue of his activity, the right to obtain personal data and specify the method and criteria of retaining, processing, or controlling such data according to a specific purpose or to his activity. So the law in this regard stated various obligations on the controller as follows. First, the controller shall obtain a license or permit from the Personal Data Protection Center to be able to practice his work. And if the controller is outside the Arab Republic of Egypt, he is required to appoint a representative inside the Arab Republic of Egypt. And the controller is obliged also to obtain a consent from the data subject to acquire or receive personal data from the competent person or entity. And after obtaining this data, the controller shall make sure that this data is valid and in conformity with the designated purpose for collecting it. Then, the controller shall set forth the method and manner for processing this personal data after collecting it. And the controller shall also not grant access to the personal data held by them except in the cases permitted by the law. And they shall take all the technical and regulatory procedures to protect and secure this data. Also, the controller shall rectify any error that occurred to the personal data immediately. And upon the expiry of the designated purpose, the controller shall erase any personal data held by them. The controller shall also maintain records relating to personal data that includes all information related to this data, as the categories of the personal data, to whom such data shall be disclosed, the disclosure, the mechanism of erasing and editing this data. Also, the controller shall enable the Personal Data Protection Center to conduct inspection and supervisions to ensure his commitment to the law. And finally, the controller shall not use any sensitive personal data without a license from the Personal Data Protection Center. And in case of using any of the data related to children, the legal guardian's consent shall be obtained. So those are the definition and obligations on the controller, and then we will move to the processor. The definition of the processor under the Egyptian data protection law is any competent, natural, or juristic person by virtue of his activity have the right to process personal data for his benefit or for the benefit of the controller by way of an agreement with the controller or in accordance with his instructions. The law in this point also mentioned various obligations on the processor as well. And those obligations are as follows. First, the processor shall obtain a license or a permit from the Personal Data Protection Center to fulfill their work. And if the processor is outside the Arab Republic of Egypt, he is required to appoint a representative inside the Arab Republic of Egypt. This obligation is similar to the controller that we have mentioned before, previously. The second one is the processor shall conduct and implement the processing method pursuant to this law and its executive regulation. Also, the processor shall ensure that the purpose of the processing and the practice is legitimate and shall not exceed this purpose and its duration. Upon the expiry of the processing duration, the processor shall erase all the personal data held by him. And also, regarding the personal data, the processor shall not grant access to it or to the processing results except in the cases permitted by the law. The processor shall not also process personal data in any manner that contradicts with the purpose of the activity of the controller. And he shall protect and secure the activity of processing the mediums, electronic devices used in processing this data. The processor shall also prepare records relating to personal data that includes all information related to such data as the processing categories, the data protection officer, the duration of the processing, the mechanism of erasing and editing this data. And last but not least in these obligations, the processor shall enable the Personal Data Protection Center to conduct inspections and supervisions to ensure his commitment to this law. And finally, the processor shall not use any sensitive personal data without a license from the Personal Data Protection Center, and in case of using any data relating to children, the legal guardian's consent shall be obtained. So those are the obligations imposed on the processor and its definition under this law, and now we will move the agreement terms. Agreement that shall be made between the controller and the processor shall be as follows, as it shall include. Okay. The Egyptian Data Protection Law didn't determine any terms that the controller or the processor shall include in this agreement. But in common practice, and as the Egyptian Data Protection Law is similar to the GDPR, we highly recommend the following terms to be included in this agreement. The agreement shall be in writing. It shall determine the obligations and the right of each party according to the Egyptian Data Protection Law. It shall determine the kind of the granted personal data and the processing duration. It shall also determine the nature and purpose of the processing, and it shall ensure the confidentiality and security of the granted personal data and the method of processing it, and ensure the compliance with the conditions determined for the processing of the personal data. Again, those terms are not included in the Egyptian Data Protection Act. We are highly recommending them to be put in the agreements between both the controller and the processor, as we have mentioned. Now we will move to our fourth point, the conditions of collecting and processing the data. As a general condition, in order to collect, process, or retain personal data, the following rules shall be fulfilled. First, this personal data shall be collected for a specific legitimate purpose. Second, this personal data shall be correct, valid, and secure. And third, this data shall be processed in a legitimate manner and in compliance with the purposes for which it is collected. And the last one is that this data shall not be retained for a duration longer than that necessary for the fulfillment of its purpose. After finishing this general conditions, we will move to a more specified conditions, which is the conditions of processing the personal data. First, for the conditions of this personal data, the data subject consent regarding this processing process shall be obtained. And second, the processing process shall be necessary and essential for the performance of contractual obligation and a legal action. And third, the processing might be made for the reason of performing any required legal obligation. And by legal obligation, we mean obligations regulated by law, order issued by the competent investigation authority, or order based upon a court judgment. And for the fourth point, to allow the controller to perform his obligation. So those are the conditions imposed on the processing of the personal data. And now we will move to our fifth point, which is the Data Protection Officer, the DPO. First, regarding the appointment of the Data Protection Officer, the Data Protection Officer shall be an employee who will be appointed by a legal representative of the juristic person of any controller or processor. And it shall be appointed in this position and to be appointed in this position, he shall be registered in the records designated for the data protection officer in the Personal Data Protection Center. And for the role of this officer, he will be responsible for the protection of the personal data held by the company he's working on. So, those are the reasons and method of appointing a data protection officer and his role. And now we will move to the obligations imposed on him under this law. The legislator imposed some restrictions and obligations on the data protection law as follows. First, he shall perform a regular evaluation of the personal data protection system to prevent the issuance of any breach to the personal data, and he shall document this evaluation as well. Also, he shall work as a direct contact point with the Personal Data Protection Center and implement their decisions. Third, he shall allow the data subject to practice his rights determined under the law. Also, he shall notify the Personal Data Protection Center in case of occurrence of any personal data breach. And he shall respond to the request submitted by the data subject and respond to the complaints filed to the Personal Data Protection Center. Also, apart from his obligations, he shall monitor the registration and the updating of the personal data record held by the controller and the processing activity record held by the processor. And he shall ensure the accuracy of all the data included on them. Finally, he shall organize the necessary training programs for the employees of this entry, and he shall eliminate any violation that occur relating to the personal data. So this is a brief about the role and the definitions of the Personal Data Protection Officer. And now we will move to the procedures of granting access to personal data. The controller and the processor shall grant access to personal data under the following procedures and conditions. First, the request to grant such access to personal data shall be in writing, shall be submitted in writing, and it shall be submitted by relevant person or according to a legal deed. Then the role of the controller and the processor in this regard shall be to ensure the existence of all the required documents to grant access to such data. And also, the controller and processor in this regard shall issue their decision regarding the submitted request within only 6 working days from the date of its submission. And in case this request was rejected, the decision shall include the reasons of this rejection. So for now, I have finished my part in the presentation, and I will leave the floor to my colleague Batool to complete.
Hello everyone, let's move to the cross-border movement of the personal data, which means to transfer, grant, access, record, store, circulate, publish, or use and display, send or receive, or process of the personal data inside Egypt to outside its borders, or vice versa. Generally, the cross-border movement of the personal data is not allowed in case of the foreign country offers a less protection level for the personal data, provided that it is allowed under the following conditions. First, obtaining the required license or permit from the Personal Data Protection Center. Second, the conformity between the nature of work of the controller or the processor or having the same purpose for which they obtain the personal data. Third, having a legitimate interest in the personal data. And last one, the legal and technical protection level offered by the foreign controller processor shall not be less from the protection level provided herein in Egypt. Although, as an exception, the law allowed the data subject or its representative to move its personal data to a foreign country that offers a less protection level for the personal data after obtaining the direct consent of the data subject or his representative in the following cases. First case is providing the medical care or treatment or performing a surgery to the data subject. Second case, perform an obligation to prove the existence of a legal right or to exercise or defend such right before the court. Third one is to conclude or execute an agreement between the processor and a third party to the data subject interest. The fourth one is to perform a procedure relating to international judiciary cooperation. The fifth one is to protect the public interest when necessary and when required by the law. After that, the case is to transfer money to another country in accordance with its valid and effective laws. And the last one is to execute a bilateral or multilateral agreement, which Egypt is considered as a party to such agreement. Let's move to the direct electronic marketing, which means to sending a statement or advertisement or marketing content by any technical means to promote goods and services. The law determines the following procedures for any electronic communication made for the purpose of electronic marketing to the data subject, which are the following. First one, obtaining the data subject prior consent. Second one is the communication shall include the identifier of its creator and sender. Third one is the sender shall have a valid address to be reached. Fourth one, the communication shall indicate its purpose is for electronic direct marketing. And the last one shall determine clear standards that grants the data subject the right to refuse such electronic communication or to withdraw his consent. Although the law obliges the sender to any electronic communication with the following obligation. First one is to determine the defined marketing purpose. Second one is to not disclose the contact details of the data subject and maintain its confidentiality. Third and last one is to maintain an electronic record that shall prove the data subject's consent and any amendment to it for a period of 3 years from the date of the last communication. Let's move to the permits, license permits and certification. The Personal Data Protection Center shall issue the following: license, permit, and certification. Let's discuss the difference between license and permit, as they are granted for the relevant person to grant him the right to deal with the personal data. But actually, the difference between them is that license is granted to the juristic person only for a period of 3 years, while the permit is granted to post-natural or juristic person for a period not exceeding 1 year, and post-license and permits can be renewed for more periods. While certification is a document that proves that the natural or juristic person has satisfied all the required requirements, qualifying him to provide consultancy service in the field of the data protection activities. Let's move to the types of license and permits and certification, which the Personal Data Protection Center is the competent authority for the issuance of such license, permits, and certification. First one, issuing the license or permits for the controller or the performer to deal with the personal data. Second one is issuing the license or permits for the direct electronic marketing. Third one is issuing licenses or permits regarding dealing with the personal data to associations, unions, and clubs. And then issuing license or permit for means of visual surveillance in public places. And then issuing license or permits regarding dealing with the sensitive data. And issuing licenses and permits for the cross-border movement of the personal data. And the last one is the issuing permits and certifications for the individuals and entities. Let's just highlight one point, that the application of license, permits, and certifications shall be submitted to the Personal Data Protection Center attached with all supported documents and required information, along with a proof of the applicant's ability to comply with the requirements and technical standards determined under this law. In all cases, the Personal Data Protection Center shall issue its decision regarding the submitted application within a period not exceeding 90 days from the date of completing the submission of all the supported documents and required information. The elapse of such period shall be considered as a refusal for such application. We assume that the executive regulation of the law will determine in detail all the supported documents and required information that shall be submitted with the application. Let's move to requests and complaints. The law grants the data subject or any relevant person the right to submit a request to the controller or the processor to exercise his right determined under this law, and the controller or the processor shall respond to such request within 6 working days from the date of submission. Also, the law grants the data subject and any relevant person the right to submit a complaint to the Personal Data Protection Center, and the center shall issue its decision regarding the submitted complaint within 30 days from the date of submission in the following cases. First one, violating the protection of the personal data. Second one, failure to enable the data subject or any relevant person to exercise the rights determined under this law. Third and last one, complaint regarding any decisions issued by the data protection officer for the personal data held by the controller or the processor in relation to the submitted request. In all cases, exercising such right by the data subject or any relevant person shall not be considered as a withdrawal for the right to refer. Let's move to point number 11 of the presentation as administrative sanctions. Under the Egyptian Data Protection Law, the Personal Data Protection Center had the right to impose the following administrative sanctions regarding any violations to the personal data on the offender. First one, a warning concerning partial or total suspension of the license, permit, or certification for a specified person. Second one, suspension of the license, permit, or certification in part or in whole. Third one is to cancel or revoke the license, permit, or certification in part or in whole. Fourth one is publishing a statement with the violation proven against the offender in media and at the offender's own cost. Last one is subjecting the controller or the processor to the Personal Data Protection Center technical supervision to ensure the protection of the personal data and at the offender's own cost. Last point of our presentation is under crimes and sanctions. The Egyptian Data Protection Law determines many sanctions for any crime execution of this law as follows. First one, a fine of an amount not less than 1,000 Egyptian pounds and not exceeding 1 million Egyptian pounds in case the holder, the controller, or the processor collected, processed, disclosed, granted access, or circulated the personal data without the consent of the data shop. This sanction shall be imprisonment for a period not less than 6 months and a fine with an amount not less than 200,000 Egyptian pounds and not exceeding 2 million Egyptian pounds in case the above acts were committed in exchange for obtaining a material or moral benefit or with the intention of exposing the data subject to danger or harm. Second, a fine of an amount not less than 1,000 Egyptian pounds and not exceeding 1 million Egyptian pounds in case the holder, the controller, or the processor refused to let the data subject exercise his rights determined under this law without determining any legal reasons for such refusal. Third one is a fine of an amount not less than 300,000 Egyptian pounds and not exceeding 3 million Egyptian pounds in case the controller or the processor did not comply with their obligations determined under this law. Fourth one is a fine of an amount less than 300,000 Egyptian pounds and not exceeding 3 million Egyptian pounds in case the controller or the processor did not comply with their obligations determined under this law. Another fine of an amount not less than 200,000 Egyptian pounds and not exceeding 2 million Egyptian pounds in case of collecting the personal data without complying with the conditions determined under this law. Although an imprisonment for a period not less than 3 months and a fine of an amount not less than 500,000 Egyptian pounds and not exceeding 5 million Egyptian pounds in case the controller or the processor collected, disclosed, stored, transmitted, saved, or granted access to sensitive data without the consent of the data subject. Although an imprisonment for a period not less than 3 months and a fine of an amount not less than 500,000 Egyptian pounds and not exceeding 5 million Egyptian pounds in case of violating the cross-border provisions under this law. Although a fine of an amount not less than 200,000 Egyptian pounds and not exceeding 2 million Egyptian pounds in case of violating the electronic marketing provisions under this law. And finally, a fine of an amount not less than 500,000 Egyptian pounds and not exceeding 5 million Egyptian pounds in case of violating the provisions relating to the license, permits, or certifications determined under this law. In all cases, the sanctions determined under this law shall be doubled with their minimum and maximum limits in case of repeating the same violation. Here we come to the end of our presentation. I want to thank you all. It was my pleasure to talking to you all. Please feel free to asking any question, and it will be our pleasure to answer all.
Yes, thank you very much to all three presenters. This was really a very interesting and in-depth presentation, and I really enjoyed to get a bit more knowledge about the new data protection law. Are there any questions in the audience? Maybe you can raise your hands and then we can see who wants to raise a question, and we can go down the list. Was everything clear? Follow-up question? I see someone. Yes. Arwa Salah, would you like to?
Yes. I would first like to thank everyone for this informative presentation. And thanks a lot, Legalia team, for this. Just to in regard to this transitional period before issuing the executive regulation, should we start from now to find processing on behalf agreements with our headquarters, for instance, if there's any cross-border transfer of data from here, or is it should we wait till the executive regulation is issued and we are more clear about the implementation on the specifically written in the law and contextual provisions? And also, I would like to ask another question regarding HR aspect. There are different all companies in the HR department of employees, and there are so many personal data.
I'm sorry, Ms. Salah. Sarah, I don't know if it's only me, but I cannot really understand your question because the connection is very bad. There's an echo.
Oh, sorry for that. I'm not sure why this is happening. Can you hear me now?
Yeah, Nora, I think I can grab. I mean, I think I'm guessing exactly the two questions. First of all, I would like to thank Mara for the questions. So I think the first questions, you say that during this transition period, how we can deal with the internal data processing agreement between the headquarter and local one. Am I correct?
Mara, yes, exactly.
Yeah, this is the first question. The second question, you're raising a question regarding what is the situation of the HR department given the transition period in terms of collecting the employee data, correct?
Yes, sure.
Perfect. So now I can take it one by one. So of course, your first question is legitimate, and we would highly recommend not to wait until the executive regulations to be issued, because now there's some maybe a general obligations in terms of the cross-border transfer. So internally, I think there should highlighting what we recommended in terms of the rooted practice from the GDPR in terms of imposing the confidentiality and the restriction of maintaining the data in confidence, and of course I think locally here as well you should be supported and secured in terms of obtaining the data from your customers, from dealers, even from your employees, to allow you to process and share this data with the headquarter, because given our humble experience, of course, the headquarter is outsourcing. This is our knowledge, and given my previous experience with international clients, they always share and process data with third-party or outsourced companies, because now the matter is getting very sophisticated in terms of having a lot of service provider in terms of to analyze the data of the customers, of the employees, of your dealers. So it would, of course, start with securing the local contracts here, either, and this will lead me to the answer to the second questions in terms of the employees. I would highly recommend, of course, to have this explicit consent either with existing employees or to put it as a boilerplate in your labor contract in the future, that you as an employer shall have the right to obtain, collect, process, and share the data with third party to secure your initial obligation under the law given this transition period. So with this, we will start looking here. The same I also see to be applicable to your contracts with suppliers, with third party, with your distributors, with your agents, or whoever, because now the matter is getting very important, and every step that you're taking, you have to make sure that at least the bottom line, you get the explicit prior consent from whoever you're dealing with internally as employee or externally with your dealers and service providers. Did this answer your questions?
Thank you very much. I think this answered the question.
Yes, thank you very much.
And I see also in the chat, Mr. Amin is asking, do you have an official English version of the law?
You know that there's no official, but I think we obtained like an unofficial English translation of the law, which we can share if needed.
I think that would be quite interesting for all participants to have, just to get an overview of the law.
Yeah.
Yeah.
Any other questions?
Oh, I see in the chat there are popping some questions up. So, Mr. Ali is asking, there was mention of licensing of data protect processor. How is that done?
This yet to be, clarified when the executive regulations to be published, because the law, of course, states on there is a regulator, which is the data protection center, is going to be the regulator in charge of issuing all the documentation, permits, a license to processor and controller. So we have to wait until the executive regulation to be published in order to get a full knowledge about all the particulars and documentation required for the processor or the controller to obtain a license or permit as provided in general manner under the law.
Okay. And Ms. Marwa has another question. What about using cloud for handling internet traffic?
Using cloud for handling internet traffic, or in other words, to store personal data as well?
Ms. Marwa, maybe you can specify your question.
Can you clarify more, Marwa?
I mean, there are a centralization of the server at the headquarters outside Egypt. This server, it's handling the internet traffic. So actually, there are the logging in and the links are centralized or can be shown on this server outside Egypt. So can this be considered, like, for instance, when I log into a certain website, people can know, people at headquarters can know that I logged in twice at so-and-so website. In this case, this would fall under the law, or it's not considered as personal data?
I think whatever. First of all, of course, given that the cloud-based services primarily as well is outsourced by international companies, and I know this. Most of the clients, they have these services to be outsourced by third party. So I think whenever it's related to data in terms of even logging in, providing data, personal data, and even professional data, I would assume, of course, under the cloud service agreement, / the outsourcing of these services, of course, there should be a dedicated section on the imposing the obligation on the third party, who is the service provider, to maintain all the data relating to your company, either the headquarters or internationally, because it has been centralized, as you said. I would assume it must include a section on the data protection, of course.
Mr. Salah is asking in general where we can find the official version, maybe also an Arabic official version of the law.
The Arabic, official version. Given that we already, you know, that this is the spirit and the of our work, that we have to be updated for all the laws and all the subsequent amendments in relation thereto. There is a dedicated website. It's called Tashri'at, or legislation, which is attached to the cabinet. It is again a subscription that is very useful, and that you can get all the official laws in Arabic and all the subsequent amendments in relation thereto. I think I would expect that like the other regulator, like antitrust agency, like the consumer protection agency, they will launch a website. I would highly expect that the data protection center, once it is established and has become up and running, they will have their own website, I would assume, and of course this will cover and include all the data protection law in it. But so far this is not available, but we are getting this through our subscription, which is the Arabic. So if anybody wants to we can send him a PDF copy of the Arabic version of the data protection law for their info. They can send an email and we can respond back to them.
That's a great offer. Thank you very much.
Yeah.
And I believe in general, the Tashri'at website is publishing only the Arabic versions of the laws, right?
Yeah, correct. Yeah.
Okay. I think you already answered Mr. Amin's question concerning the Data Protection Center, whether it's established or not, and how we can deal with this center if they have a website. So all this is still not established so far, right?
Yeah, correct.
Okay, and Ms. Marwa would like to know if the sanctions can be implemented retroactively.
Legally speaking, no, because you know that as a legal principle, that the law cannot be applied retroactively unless it has been stated clearly in that. So, given the direct review of the provision of the law is going to be an ipso facto application, meaning that with immediate effect, and cannot be retroactive, because the law did not explicitly state on the retroactive effect and or application of the law in its provisions.
Yes, I believe so.
Yeah.
Okay, thank you very much, Dr. Hamdy. This was really very, very, very to the point, and for me, I learned really a lot today during this webinar. That was really great.
From our side, we'd like to thank you, and we'd like the German Chamber of Commerce. Also, we'd like all the participants, and we thank them for their patience, because we showered them with a lot of information. Of course, things can be revisited once the executive regulations have been published, and we're happy that we can have another round for more clarification about the application of the law when the executive regulations have been published. Finally, again, we'd like to thank you, the German Chamber of Commerce, all the participants, and thanks again for your patience. And we're more than happy to answer any questions by sending emails or whatever to us. And thanks again for your time.
Thank you very much, Dr. Hamdy. And I think it's a great idea to have a follow-up webinar once the executive regulations are out, because then the law will get its body more and more, and then we really will understand its impact. So great. I think it's a good idea that we will have a follow-up session.
Thank you, and thanks for your time.
Yeah, thank you.
Thank you.
Okay.
Bye. Thanks. Bye-bye.
And we close this meeting here
Thanks.
now.
Bye-bye.
Okay. Bye-bye.